In the spirit of reconciliation, Law Squared acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today.
Hello and welcome to Return, Respect and Remuneration, Employment Trends to Look Out For in 2025, presented to you by Law Squared. I'm your host, Employment and Workplace Relations lawyer Amok Gadhe. It's no exaggeration to say that today's discussion is a really important one for in-house lawyers as well as HR leaders and senior managers, as we unpack three of the most significant employment trends likely to be impacting businesses and organizations in 2025. 2024, as many will be aware, has been a big change in the employment law landscape, with a whole array of changes coming into force with the Closing Loopholes Acts, some of the more publicized ones, of course, being things like the right to disconnect. However, if you thought that 2025 would be a chance for you to rest on your laurels, think again. It's our prediction that between the proactive duties imposed by the Respect at Work mandate, the ongoing and often difficult juggling exercise required to manage return to office policies, and the introduction of criminal penalties for intentional underpayment, regulators will be taking a zero-tolerance approach to these issues. We're going to cover a lot of ground today, so let's get straight into the conversation with the introduction of our esteemed panel of experts. Joining us today are D&E Air Conditioning General Manager for People and Culture, Sonia Law, Company Secretary and General Counsel for Movember, and former General Counsel of Movember, Kate Bennett, and Law Squared's Employment and Workplace Relations lawyer, Jess John. Together, we will explore the practical and legal steps organizations can take now to create happier, healthier, and safer workplaces in 2025. But first, let's get to know our panelists a little bit better. I'll start with Sonia Law. Sonia is the General Manager for People and Culture at D&E Air Conditioning, a company that has over 600 talented employees who provide mechanical services solutions to our clients in the construction industry, completing projects in residential, commercial offices, health, defense, and data centers. Sonia's background is in the mining and the water industry, and she's also the chair of the Human Resources Summit in Sydney and Melbourne. I'm so pleased to have you join us today, Sonia.
Thank you so much. Thanks for having me.
I'm also delighted to be joined by a great friend of Law Squared, Kate Bennett. Kate is Company Secretary and former General Counsel of Movember, a global men's health charity. Kate brings extensive experience in a variety of legal and commercial leadership positions across public and not-for-profit sectors to our discussion today. And it's that wealth of experience and knowledge that we here at Law Squared are lucky to have, as Kate is also our legal mentor. Kate is also an alumni of the Stanford Graduate School of Business and has previously been named as Not-for-Profit Lawyer of the Year twice by Association of Corporate Counsel in Australia. Kate, we're so glad to have you join us today.
Thanks, Amog. Really glad to be here too.
And finally, someone who many of our viewers will recognize, Jess John, my colleague in the Employment and Workplace Relations team here at Law Squared. Jess has extensive experience managing a broad range of employment matters, including handling claims in the Fair Work Commission, as well as state anti-discrimination commissions and employment cases in the Federal Circuit and Family Court of Australia. Jess regularly works with our clients in the not-for-profit space and has supported many senior managers and leaders navigate difficult employment issues within their workplaces. Pleasure to have you with us, Jess.
Thanks, Morgan, and really great to engage in discussions with Sonia and Kate about what's ahead in 2025.
Awesome. Now, before we get started, a quick word on housekeeping. To help us keep to time today, we are going to take questions in the chat bar. No doubt we'll cover many of these in the course of our conversation, but if we can't get to some of the questions today, we'll definitely be responding to those after the webcast and circulating the responses to all of our viewers. So please don't be shy. Please drop in your questions in the sidebar, and our chat moderator, Alicia, will make sure we get to these right after the webcast. So with that in mind, let's dive into our first trend of the session today, which is Respect at Work. Jess, the Respect at Work report made about 55 recommendations, most of which have now been implemented by the Australian government and also legislated upon. For the benefit of our viewers, could you provide us with a little background on what behaviors Respect at Work encompasses and what are the aims of the legislation?
Yeah, thanks, Amog. It's a good question. So the Respect at Work report was published in 2020. It kind of followed a national inquiry back in 2018 by the Sexual Discrimination Commissioner. And it was kind of based on all of the heightened awareness from the Me Too movement in 2017. There was a survey done in 2018 where it said that 2 in 5 women, so 39%, and over 1 in 4 men, so 26%, experienced sexual harassment within a 5-year period in the workplace. And that kind of report emphasised the need to kind of deal with these issues. So based on that legal definition of what sexual harassment is that it's unwelcome sexual advances, requests, sexual favours, and unwelcome conduct of a sexual nature that kind of offends, humiliates, or intimidates an individual. I guess the broader aims of the legislation is kind of this preventative shift. It's about reducing harassment by implementing kind of proactive policies as opposed to being reactive to the issues that are raised by employees through the course of their employment. Along with that, you've got to address some of the economic impacts that deal with that. Primarily, and what I've read is that annually there is $3.8 billion worth of costs that's associated with sexual harassment in terms of turnover, absenteeism. You're looking at lost productivity, and that's a significant cost, along with kind of the cultural impacts that are dealt with, you deal with in terms of sexual harassment. So the 2020 report, it was published, and then there's been a series of amendments across 2020 till now, where it's taken some of those 55 recommendations and put them into law. So there's changes in the Sex Discrimination Act, where it's about prohibitions on sexual harassment in terms of clarifying the employer and employees' legal responsibilities. You've got changes to the Fair Work Act, primarily around the Stop Sexual Harassment Order, where similar to the bullying stop order, the Commissioner are able to kind of arbitrate those matters and issue a stop order for sexual harassment. In the Australian Human Rights Commission, we've seen amendments in relation to timeframes. So previously you had 6 months to lodge something in the Australian Human Rights Commission. Now it's extended to 24 months. So it gives the applicant, the employee, a safer, more accessible process when dealing with those types of claims. So the number of different amendments based on the recommendations of the respective work report have come through over the last few years.
Yeah, no, thank you for that and for setting that out so clearly. Just to kind of piggyback off one of those amendments, you mentioned the Australian Human Rights Commission Act, and there was an amendment to that, I believe, as well, in relation to getting it to come close to the Fair Work Act when setting standards around costs, particularly when litigants are trying to go to court in relation to sexual harassment. Could you explain how these changes have come into force in relation to the cost protections under this amendment?
Definitely. So there's been 55 recommendations, and number 25, which is actually the 25th recommendation, is the last one that's going to be implemented, and that's going to come through in 2025. So that's in relation to the recommendation in the respective work report that talked about that there's been some hesitancy by employees to lodge claims in the respective jurisdictions because of the costs that might come back at them. So previously, costs followed the event. So what that means is that the losing party in litigation would pay the winning party's costs. And what that causes is kind of discouraging potential applicants from initiating these claims. But based on the recommendation, what's changed and shifted is that the liability for applicants to harbour those costs have been reduced. And it's kind of falls in line with some of the legislation that's in the Fair Work Act, so Section 570, that talks about that it's a no-cost jurisdiction, that it's a party cost. The costs are attributed to either party. But there are restrictions that have been put in place for respondents. So what that means is that there are circumstances where the applicant can claim costs against the respondent if they are successful. So what that means from a practical point of view is that it's talking about that shift from a reactive culture to a preventative culture, that potentially there will be more claims that are lodged in the associated jurisdictions. And it means that employers need to be proactive around how they deal with these types of matters, whether that's through policies and training, so that potentially you'd look to try and resolve these matters via settlement before it does go to final hearing because of these litigation cost risks.
Absolutely. And thank you for setting that out as well. Now, Sonia, if we go beyond the sort of legal implications, what are the impacts on the workforce when these types of misconduct behaviors go unchecked? In other words, why is this important beyond just sort of mere compliance?
Yes, it's something we're definitely thinking about in HR in terms of we're always thinking about culture impact. So we like to take a proactive step in terms of through culture surveys that are anonymous, trying to get a sense of would people speak up if there was an issue, and do we have a process in place if there's a grievance? Something that we have at D&E now is myself in the role of HR. They haven't previously had someone in that role. I think they've done a great job thus far, but having someone who is trained to listen and to deal with such sensitive, complex matters when they arise is a really great investment by D&E and gives people working here confidence. So I think for me too, I like to stay up to date and educate myself, and I take guidance from previous cases as well. There was one with BHP talking about a coal mine site, and it was a sexual harassment claim. And then I looked at the commissioner and what he'd said and how he kind of read that situation. So I take a lot of the things that I do from that. So the way I use that, for example, at D&E, we're in the construction industry and we're not immune to certain behaviours on site, which may not be directly related to D&E, but we do share space and environment with other trades. And we know the construction industry is definitely something that the Fair Work Commission is looking at, and they've actually set up a national sort of industry forum to look at it specifically. So I do communicate to leaders just because it's a construction site and that's the way it was. In the determination from the commissioner, he said it's no longer acceptable, that it's just the way it is on a coal mine site. So I say it's not acceptable also on a construction site. So we need to be more sensitive to reports. So I think, to Jess's point, a lot of people don't potentially raise it, maybe latent because of cost, or they don't raise it perhaps because they might be victimised. I think at the coalface we actually need to just be very aware of what our culture is, and that the access to report and that people feel comfortable to speak up. Our approach here at D&E is just really that open, transparent communication, understanding what the issues are through surveys and exit interviews, and then having a process in place where we can work through things themselves. And then my further communication to the leadership team is is to be proactive also and asking for feedback. And particularly with women, one of the things that we've taken up is to speak to every female on site in a construction site. So I speak to them regularly each week, and I actually ask them how the culture is. So it's a very proactive step. And then we've set up a forum where we're going to engage with each other regularly, where I'll go out on site. So that's probably our biggest sort of risk factor in terms of respect at the moment.
Absolutely. And you raise a great point, culture, communication, but also engaging with your employees and regularly engaging definitely creates that confidence in employees that they can speak up when these sorts of issues arise. So absolutely, great point. Now, one of the important legal points, just to come back to you, Jess, was with respect to this positive duty that is now imparted on employers. Could you talk a bit about what that positive duty is under the Respect at Work changes?
Yeah, and if you're looking at that landscape again of this preventative culture, it really lends well to this positive duty, which is employers need to take reasonable and proportionate steps to prevent sexual harassment from being in the workplace, and it's kind of aligning with some of the OC health and safety kind of situation where you're trying to prevent the risks, you're trying to assess the risks, you need to mitigate those risks, which I think is really welcome. So when you're looking at that kind of effective compliance of positive duties, you're looking at risk assessments, determining where if you are in, say, an industry that is male-dominated, that you look at those power imbalances and assess those power imbalances. You've got policies and procedures in place that sets out what is required when dealing with sexual harassment. Reporting is important. There's a lot of good resources in the Respect at Work website that you can use, and you can obviously come to us as well, and we can draft policies for you. But the main thing is that you need really solid policies and procedures, and the other one is training. Training. We talk about this to clients all the time, and it's really needs to be specific in that there should be some competency-based training. And what that looks like is that employees need to demonstrate their understanding of what sexual harassment is, what constitutes harassment, and what are some of the kind of preventative behaviours that need to be displayed in relation to sexual harassment. And to Sonia's point, it is that kind of anonymous reporting mechanisms where employees feel safe to be able to report that in channels that without that fear of kind of retaliation or victimization, which is really important as well. And then those support systems, so EAP, being able to speak to particular people within the business that can kind of support them through that process. They're the main things.
Yeah, absolutely. And you're right. It's that almost that interplay between legal and HR, which we'll touch on later in the session as well, that you need both sort of teams to work collaboratively to tackle this. So with the risks increasing, the pressure is on to truly embed cultural change. And Sonia, you sort of flagged about this earlier. I'm sure you've encountered this given some of the industries you've worked with. Could you share your thoughts on what it takes to shift from a mere compliance to a culture that values respect as a foundational principle? What are some resistance points that people and culture leaders, or even general counsels for that matter, will likely come up against?
Yes, certainly. I would always say that it's led. So at the leadership table, very much you have to have respect amongst your colleagues, that you're communicating well with each other, that you understand what the risks are, and you actually have a forum where you're meeting regularly to discuss that risk profile. And part of that is respect, because so much flows from that in terms of trust and behaviours, thoughts and actions. So I think unity at the leadership level is the most important thing in my experience with regards to respect. That's the first thing. And then it's to monitor through, yes, that proactive sort of culture surveys, but also you get a lot of data through observation. You also get a lot of data through staff turnover, how they conduct redundancies is a big indication as well. Do they conduct exit interviews? How they treat people? It all comes down to respect. I think respect too is the knowledge of the business. So the more knowledgeable people are, the more likely they're to, leaders that is, to respond in the right way. So I think that's really important too. And relationships with people. I always try and coach leaders to be more authentic, and that the workplace is an extension of them, and it's actually okay to be themselves. And that actually helps to form a good relationship with people and good respect. If some of the issues are probably through not doing that. When you do not have a united leadership team who communicates, that trust each other, that work well together, that's where definitely the cracks start to appear. They're not interested in what the people think and feel, so they have no surveys or no mechanism for that, for people existing or leaving. They usually have, they're usually always in Fair Work. They're always in the court, and they have a huge turnover, is usually symptomatic of all of that. There's a lot of reporting of grievances. In a good culture, you have good culture results. You can observe it. It's a felt thing, and it's led from the top.
Absolutely. No, 100%. Now, Kate, I want to bring you in here as well, as I know you've been quite instrumental in driving cultural change in a fast-growing organization. What advice do you have for senior leadership, particularly from a sort of GC lens, when managers aren't persuaded by the sort of good business arguments? What are the financial and risk-based arguments that might potentially be more impactful or strike a chord?
Yeah, it's a good question, Morgan. I think, firstly, I'd say I've been lucky to be in organisations where I haven't had to grapple with management not being convinced by the value of that sort of stuff. And I think, to build on kind of what Sonia was talking about, if you're in a leadership team that isn't modelling that behaviour and is struggling to, I guess, buy into the importance of that, I guess my first piece of advice would be think about whether that's the right leadership team to be a part of. There's some pretty red flags for me in terms of culture. But if you do need to look at the kind of hardline, bottom line risks, they're everywhere. Sonia touched on them. So the cost of turnover, the cost of not retaining talent in terms of knowledge retention into your organisation, but also the cost of then going through recruitment, managing time and exit interviews, grievance claims, Fair Work claims is huge. There's reputational risk that can be incredibly damaging. So we've talked about, Sonia's mentioned BHP as an example. You don't want to be on the front page of any newspaper or the Financial Review for this sort of stuff. But then there's also just the actual cost of managing claims. So whether you have to pay lawyers to deal with that, or a loss in productivity because of the amount of time that you have to spend dealing with that claim and working through it and settling it, that can be devastating to an organisation. It can also really have impacts on the culture, which then have ripple effects on productivity, etc. So you can't look at culture in isolation. I'm sure Sonia agrees with that. And I think that proactive duty, it's just becoming how businesses operate. We need to operate in a way that means that it is important, it is prioritised and at the forefront of everyone's activities when they're thinking about how do I do something, what does that mean for people, and how safe are the people who are turning up to work, and how do they feel about turning up to work. That's how you get the best out of people, and that's how you drive results.
Absolutely. The sort of trickle-down effects are real. If you set the good behavior at the top, it will flow on to the rest of the organization as well. So absolutely. And I'm sure we can talk about this particular trend for a lot longer, but I think in the interest of time, we'll move on to the second trend for the webcast, which is return to office or return to work sort of mandates. Now, the shift to in-office work or even hybrid setups remains a pretty complex topic for a lot of people, especially with international examples pushing the conversation. In Australia, as many of our viewers will be aware, there isn't a legislative right to flexible work or remote work, although employees can make requests to their employers after they've worked for 12 months. However, the employers are able to refuse that request if it is in one of those grounds that is set out in the Fair Work Act. So there isn't a legislative entitlement per se. And also, it's important to note that often people confuse remote work and work from home. Remote work and flexible work, rather, is a bigger umbrella, and flexible work can include a whole host of other examples, including changing hours or working from home, working remotely. Like, there's a whole list of things that constitute flexible work, so it's not just working from home. Now, Kate, greater flexibility is enormously popular with employees, and in a post-COVID world, many employees highly prioritize this over other workplace incentives. So given the war for talent, that the war for talent sort of always continues, what's driving employers to implement return to work or return to office trends? I'm thinking about productivity arguments here in particular, where CEOs, for example, have come out saying, we want people in the office because they're more productive when they're in the office. Is that really true?
Yeah, I think, look, the world has shifted, hasn't it? We went from everyone having to work at home and having to navigate that and figure that out to very much this space where different businesses are putting in mandates to return to the office full-time or sometimes part-time. And I think the world of work in scenarios where that's possible has changed. The EVP has changed for talent. And if you're not grappling with that, you're probably either losing your really good talent or you're just not in the market for good talent when you're recruiting. From a productivity point of view, I think it's forcing potentially the dinosaurs of the working world to think about productivity perhaps more in terms of outcomes and outputs as opposed to just presenteeism. And so, look, it's not an easy area to navigate, and it's also not possible for everyone. So remote working, if you work in retail or you're on the front line, you're emergency services, if you're a trade, that's just not possible. Flexible working, I think, is more possible, but still presents some difficulties, particularly for trades and people who are working in shift-based environments. And so I think despite what the legislation requires, again, with that cultural and talent retention focus in mind, we have to be thinking about how can we provide flexibility so that people can balance their work and life and be more interested in doing that.
Absolutely. And sorry, just to press you on that point a bit more, Kate, from an employee's perspective, obviously employers have their list of reasons as to why they might want people to be in the office. But from an employee's perspective, why are we seeing this almost a trend where employees are now wanting that flexibility? I mean, flexibility in workplaces has existed even before COVID, but more recently we've seen a lot of employees just wanting to work from home or wanting to work flexibly. What are your thoughts on that?
I think that's right. I worked in an organisation pre-COVID where flexibility was already built into the culture and the ways of working. But I think for a lot of people, COVID was the first introduction to being able to try different methods and modes of work. And I think a lot of people have realised that they actually do want that flexibility. That's important to them. I think we have a different generation of employees kind of coming through who are quite willing to make other sacrifices in order to have that flexibility and to prioritise different things in their lives. I know as a graduate, you commuted into work and you were there 9 to 5 and that was the expectation and that was just kind of what people did, but that's not really how people are living their lives anymore. And so if you're not able to accommodate that, what you'll find is that there's great talent out there that's just not willing to bend on some of the things that they want. And I think the key to flexibility, and I'm sure Sonia has views on this, is it's a balance in both directions. So you have to be able to make work for both employer and employee. And if you can't, you're either going to have your employees walk away or you end up probably with a dispute because the employment situation just doesn't work in that situation.
Absolutely. And just before we move on to the next question, Sonia, did you have any thoughts on that or anything to add on that point?
Yes. I guess something unique to D&E is typically we don't do work from home. We're definitely champions of flexibility and taking the situation. And in fact, flexibility is excellent at D&E. It's just that for us, our model is delivery, essentially in a high fast-paced, dynamic industry of construction. So what we more look at it like is in terms of innovation. So D&E is incredibly innovative, and the three business owners, private owners, actually work in our head office here in Rowville, and they're on the floor and they're working with the estimators, the engineers, the draftees, the project managers. It's very dynamic, and it's actually a really fun place to be. And we all learn from each other and we solve problems. And it's kind of really exciting to come into the office. So it's probably a preference for most. But it creates these centres of excellence, and now it's becoming almost a competitive advantage for talent. So people wanting to come to D&E from our competitors because they've heard that you learn more, you solve problems, it's dynamic, it's great for your career. You get to work on some really interesting projects and jobs. So we're looking at it more in terms of innovation and, being together. The social aspects too. We have a communal kitchen. So it's somewhere where people can go and talk, and we learned from COVID that's really important. And in fact, working from home can affect, in some cases, our mental health, and it's very gradual over a period of time. So it's good to come into work and, have that social contact. So I guess, for us here at D&E, it's all hands on deck, and it's going well.
Absolutely. No, and that's great to hear. And you're right. It's a balancing exercise, I think, with flexible work. And that's why it's, important to flag that flexible work does not equal work from home. There's many other forms of flexibility, and each organization, as well as their employees, will, have thoughts on what they would like from that. So it's not just this one simple linear concept. Now, Jess, can you update our viewers on the regulatory sort of developments impacting flexible remote work, and perhaps sort of some examples that other Australian businesses might be doing, perhaps?
Yeah. Thanks, Margaret. And I guess for employees that don't work at D&E or that don't work at the organisations that Kate works at, there are other things that employees can do within the commission to kind of deal with some of the flexible work issues that kind of arise. One of the provisions that have come in mid last year is this change in the Fair Work Act, so Section 65, where it talks about how the Commission can kind of arbitrate some of the disputes that employees and employers have about these flexible work arrangements. And rightly said, Amog, that flexible work arrangements aren't always just about work from home, but sometimes they are. And there's been two cases in recent times where they do talk about that. And while there has been a shift to be more flexible within Australia, these two particular cases do demonstrate that if the business does have reasonable business grounds, like D&E does, that's fine. That the application will be dismissed, and the employer, if they can demonstrate those reasonable business grounds, can deny that request. So if we look at Jordan Quirk and BSR Australia, there was kind of some specific requirements that were outlined in Section 65, and the Commission kind of upheld it because that particular employee wasn't eligible for those flexible work arrangements. There's the case that you'll see proliferated across LinkedIn. It's the Gregory and Maxia case. Most people would have read it, but it's full-time work from home. They were citing that there's issues, the employer was citing there's issues around supervision and productivity, and that's the reason why they've denied the work from home request. And the Commission stated that, yes, it is on reasonable business grounds based on productivity and supervision. So that's really important. But as we move forward, there has been some kind of proposed changes to the Clark's Award to include a kind of model work from home clause, which is, I find really interesting. And it's similar to the things the Commission has done over the years. So if you look at 2011, they implemented a redundancy model award clause kind of setting out and standardizing a lot of the awards to include that redundancy model award clause. In 2019, we had the annualized wage salary model clause. So I think they are using the Clark's Awards as a test bed to see whether they can identify a model award clause that is suitable for people that are covered under the Clark's Award. Because, there's about, from the stats, there's about 41.4% of people that are under that award that do work from home. So setting those arrangements out, and then I think the Commission, as time progresses, will start to look at implementing that across other modern awards once they start to get the detail out of the way. So that's what the Commission's doing, and businesses are doing things as well. So if you look at Bunnings and Medibank, they're instituting the 4-day work week, which has been successful from what I've read. So Bunnings has said that over the last 3 years, they've actually provided paid rises, a pay increase of kind of 10.5%, which is significant, nothing to laugh at. And then Medibank is running this model of 100, 80, 100, which is 100% pay, 80% time, and then 100% productivity, which is good and seems like that's working as well. So a lot is happening in Australia, and it really is. And to use a typical lawyer term, it depends. Flexibility depends. So you just need to determine, based on reasonable business grounds, what works for you and what works for your employee.
Absolutely. And it also goes to Kate's point earlier around the outcomes. So a lot of these examples you pointed out with Medibank and Bunnings, if the focus remains on outcomes, then as long as employees are taking those outcomes, it doesn't matter if they're working 5 days a week or 4 days a week. Like, it makes no difference as long as you're, getting those things done. So sorry, I didn't mean to cut you, Jessica.
No. And that's a great point, Amod. And I think while it's in Australia, there's been a lot of developments, but overseas, there's been developments as well. If you look at Germany, they do have this kind of cross-border remote work arrangement where you can spend 50% of your time in a neighbouring country, but still have your social security coverage, which I think is great. Netherlands and New Zealand have similar arrangements in terms of flexible work that's similar to Australia. I think New Zealand has like a digital nomad visa as well. So there is a global movement around flexibility, but it doesn't mean that employers need to give in to the flexible work requests that have been provided by employers. But we are seeing that shift.
Absolutely. And there's still that obligation on the employer's part to respond to it. So that's one of the changes under the new legislation, that you still have to say yes or no, even if it is a no. So that communication and kind of ensuring that employees are kept aware piece is quite important as well. And you're right, like in terms of the Clark's Award as well, some modern awards or some industries or some roles will lend themselves to more working from home or, flexible working arrangements. But that's not going to be the case for all employees or all roles. And so it is really about figuring out how it applies, as well as giving employers a bit of flexibility in terms of ensuring that they are doing what is best for their business, but also for the employees and their well-being. Now, to piggyback off that, Kate, plenty of employers genuinely want to provide greater work-life balance in their policies, but there's, of course, a risk that this can backfire, where flexible working or work-from-home policies are perceived as inconsistent or inequitable. I think we all recognize that some roles, as I said, would inherently require people to be in the office or in person. How can organizations make these distinctions clear, as well as ensure that there's equity that's upheld?
It's tricky. So I think, the first thing I've just learned is that Jess is an encyclopedia of options around flexibility. What I think that demonstrates is for every organisation and in every setting, there are so many different options. And so I think sometimes narrowing down for your organisation and your setting, what are the options that sort of make sense, is a good place to start. Doesn't mean you have to limit that, because employees may have ideas that are workable that you haven't thought about. But if you start with that and you put a policy in place that kind of provides those examples, it's really clear about what options might be viable. and how to make those requests, I think the piece where you can succeed and fail is then making it really clear about how you will make that decision and on what are the decision points around that, and then being explicit and reasonably transparent about what those decisions are on a case-by-case basis. So that doesn't necessarily mean, in fact, I probably wouldn't recommend it should mean, that every time somebody comes to you, you publish the decision that you make on that point on your intranet or something like that. But what I would suggest is that if somebody makes a request for flexibility, and maybe it's as simple as I want to have a compressed work week, you look at your policy as a decision maker, you look at the points that that you've said that you'll consider, and then you respond to that employee with whether it's a yes or a no or an alternative, making reference to those points. So tell the person, I've said no on this occasion because you've had performance issues recently and I'm concerned about productivity. So let's get through that, and in 6 months we might consider this again. Or I've said yes, here are my concerns, let's trial it for 6 months and see how it goes. And what that does is in some ways it forces you to be a bit more consistent in how you're making those decisions, because you have to stop and think about what you're saying and why you're saying yes or no. But the fact is there are plenty of organisations who will have people working in different roles where it will be a little bit inequitable. So if you work in a hospital, for example, hospital administrators may have greater access to flexibility than you would expect, say, nursing staff or clinical staff, because they have to be face-to-face and they work on set shifts. And that is something that I think just culturally different organisations have to find ways to grapple with in their own settings.
Absolutely. And it's a great point you make, because that sort of is a great segue into my next question around policies. So if you come at it from a different perspective, Kate, how are forward-thinking employers crafting flexibility within their workplace policies? Because as you rightly pointed out, there's bound to be some inequity, especially given the different roles. However, employees, I'm assuming, still want to see a uniformity when it comes to process or when it comes to policies that apply to kind of everyone. So how are employers kind of tackling this?
Yeah, look, I think you're right. I think the key point is, generally speaking, people want to see equity in process and transparency and fairness, and that's a big help, even when the outcomes may be not necessarily balanced because of different circumstances. I'm probably not the font of all knowledge on this, but I would say organisations that are good at attracting and retaining talent are really good at thinking about what's the EVP that suits the type of people that they're looking for in their organisation. And they are mindful of what is important to those types of people. So if you are a law firm who's looking to attract a bunch of new grads, then thinking about ways to speak to those grads in their language and to what they're looking for in employers is a really good idea. If you sort of say, well, we're 5 days a week and we're really traditional and you're going to be doing that, you're going to attract a certain type of employee, and that's okay, but that may not be what you're looking for. On the flip side, if you are an organisation where that is the type of work you do, if you're a traditional law firm and you want people to be face-to-face with clients in the office in that old school kind of setting, then don't offer flexibility if you're not prepared to go through with that. And Sonia, you made a really good point that your organisation has made some really clear decisions about being based kind of physically at your location. And I'm sure that you're telling people that up front so that they're not joining the organisation with a whole bunch of ideas about what they want and then finding that that's not playing out. So I think, I sort of haven't answered your question in some ways, but I think what I'm saying is communication is really important, and thinking about what you're trying to achieve and who you're trying to attract into your organisation is probably where I would start.
Absolutely. And I think you're right in the sense also that, the policies are meant to evolve with the organization. And so what flexibility means for an organization today may not mean the same in sort of 1 year's time. So it's ensuring that you're constantly reviewing the policies as well so that they're fit for purpose and not the only document that employees look at as the organization changes. And from that, obviously, it's also clear that transparent, clear, and consistent communication is quite important as well within the space. Now, one final question from me on this trend: do any of our guests have any advice for how managers, senior managers, can address employee resistance to this return to office policy? Then we've talked about like communication and embedding a good culture and so on. But was there anything else that any of our panelists wanted to talk about, particularly from a managerial behavior perspective and how they might tackle some employee resistance?
So what Kate said, I don't know if you know, so I was busily writing so many notes because this is exactly where we're at the moment in terms of communicating and what it is that we're doing. So in the survey, it says that, we don't offer work from home and that we're being inconsistent. However, we are doing so much in the flexibility stakes and in the options that just articulated. So for us, my advice to the leadership team at the next meeting is it's a PR exercise, that we actually need to communicate that we are physically at office because we want to provide the best environment to be social, to be recognised, to collaborate, to innovate, to solve problems. And that's a very dynamic environment in which, we can learn and grow, our careers. We can work closely with the directors, but actually to be upfront about what it is that we do in terms of flexing and what it isn't. So we don't necessarily have the issue of the mandate of return to office because it doesn't exist. But I think just to Kate's point, for any organisation sort of grappling with this, and this is the hot topic for us at the moment because we are thinking about talent and retention and attraction, I think it's really understanding, as Kate said, what that employee value proposition is so that you're very much, attracting the right talent that's going to stay and going to enjoy that environment. And then people can self-select. That's not for me. I want an office where it's more a balance of work from home. And I think that then is being preventative and proactive in that you're not less likely to get some issues coming up because it's kind of stated up front. And when people choose it, it's very empowering. And we do want an empowering workforce. We don't want people to feel like they're not being cared for and their situation is not being considered, because that's the opposite of what we want to do. So for us, it's a PR exercise. It's about innovation.
Absolutely. Jess or Kate, did you have anything else to add to that?
Yeah, quickly, it's just about that communication that kind of Sonia and Kate were touching on. Putting my lawyer hat back on, it's I see a lot of the claims that are lodged in the commission and courts because of that lack of communication between the employee and the employer. So if you progress that communication to a point where everyone's on the same page, you are kind of mitigating some of those risks from a litigation point of view.
Yeah, I couldn't agree more with that. And I think the piece that often gets lost in there is training for managers. Managers don't just kind of turn up and know what to do. And I think communication often slips because managers aren't quite sure how to have a difficult conversation when the answer might be no, or it might be, can we try something different? And so making sure that you train your managers on what is your EVP and how do you communicate and have those difficult conversations is half the battle.
Absolutely. And I guess it also allows employees then to feel comfortable to have those conversations with you if you've shown them that you're willing, even if it is a no, like you said, Kate, you've shown that you're willing to have a chat and at least see how there's any potential solutions you can come to. Awesome. So once again, similar to the last time, we can talk about this for ages, but I think in the interest of time, I'll move on to the final trend for this webcast, which is around remuneration and wage theft. Now, new wage theft legislation takes effect on 1st of January 2025, where a criminal penalty has been introduced for employers deliberately or intentionally underpaying their staff. Jess, can you start by talking about what's prompted this legislative intervention in the space?
Yeah. I love talking about history. So it really just came out of some of the issues that happened in 2014 through the, I probably would have heard it, the 7-Eleven scandal, where particularly migrants and student workers were underpaid and exploited. And that kind of led to a public outcry for stronger protections. And then as we've progressed, we do have these kind of wage theft laws that initially came out in Victoria and Queensland, but now have been federally legislated, which is really good. And what that means is that it's that spectrum. So you've got unintentional wage theft, underpayments, and then you've got this intentional underpayments. And this is the legislation kind of captures the higher end of those issues. If you think about some of the stats that have come out in the Federal Ombudsman's 2023-2024 report, they have recovered $473 million worth of unpaid wages. That's kind of 150,000 workers. So it's a big problem. So the Ombudsman is looking at trying to cultivate in Australia a culture of compliance, which is so difficult because there are financial pressures for employers, but it's trying to deal with some of the intentional issues, intentional underpayments that are coming through, and connecting it to some of the occupational health and safety provisions that are out there already. It's okay, we've got civil penalties and criminal penalties for the health and safety legislation. How about we do the same for wage theft, for underpayments? And the idea is that if there are criminal provisions that are attached to these types of contraventions, that there will be that greater increase of compliance culture through that process. And, it's 10 years worth of prison, and potentially the civil penalties have also increased. You're looking at $7.8 million of fine for companies. So there's some big risks now for employers to consider when they're kind of dealing with underpayments, and that if someone in the boardroom thinks that it might be best if we cut corners, it might not be the best thing to do. And not that any of our clients would consider that, I'd say.
Absolutely. And you're absolutely right. Like this, particularly around like deliberate or intentional wage theft is where the criminal penalty kicks in, just for the viewers as well. And financial penalties obviously are quite substantial, like you rightly pointed out, Jess. And, one only has to Google underpayments and you'll see a whole plethora of examples, whether it's large banks or whether it's other organizations in other industries that have recently fallen trap to underpayments. And, on the surface of it, it doesn't seem that hard. Just pay your employees what they're meant to be paid. But employees or employers can sometimes sort of, miss that. Now, wage theft is not going to be tolerated in 2025, but what are some underlying causes, do we think, of this? Is it just a case of bad bosses, or is it incompetent payroll staff, or is it something else? Kate or Sonia, what are your thoughts on this? Who's to blame here?
I would like to think that most underpayments are accidental. Now, obviously, the wage theft provisions account for the fact that some of them aren't. But Sonia, I'm sure you've seen this in more places than I have, but you can have a whole bunch of different types of staff in an organisation on different awards with different entitlements, and it is difficult for payroll staff to keep up with that. So even though that's their job and they're required to, I think accidents do happen. And really the key is to make sure that when you figure them out, that you fix them really quickly. And then there's a cultural piece there, and it is around cutting corners and looking at, well, I don't want to pay on entitlements. I want to pay what I've decided is the market rate. Sonia, I'm sure you've seen many other examples of that.
Definitely. I agree. Most underpayments are unintentional, and with payroll, it's largely about interpretation, and they fall into the trap sometimes of applying a bad rule consistently. That's one thing I've seen. And the other one is literally an Excel spreadsheet, which just has the wrong formula, and no one's really checked it. And then the CFO at the end of year checks it and goes, oh, okay, somewhere along the line, it's not working. So As you say, that's something that we jump onto straight away, understand the size of the problem, who it's impacted, and then we get legal advice on how to communicate that, particularly if there's an enterprise agreement or under particular awards, how do we need to communicate that and what's the remedy, and to have that all signed off by the board and then just action it. And that's probably been more my experience, that business owners want to do the right thing. And yeah, I've never worked in organisations where they're deliberately, intentionally doing that. And with the board here, I've communicated the changes in legislation in relation to wage theft and what it means and what are the penalties, so they understand that's a very serious topic. And, we need to look at potentially doing some audits of what awards we're applying. We are fortunate in that 2/3 of the organisation are under an enterprise agreement, so it's very strict. So problems we've picked up very quickly. But I think with the office being a third, an award interpretation can be an issue.
Absolutely. And absolutely a regular compliance and reviewing of the awards or even EBAs. And I think you're absolutely right, Sonia, which with the award interpretation, which tends to be quite subjective, generally speaking. So people in different levels might change depending on, how their job description changes and so on and so forth. So it's just that regularity in regular reviews, the key, I guess, from that point. Now, we are almost out of time, so I just want to ask Jess one final question. What are some practical strategies for how legal teams might be able to support clients with this issue?
Yeah. The first practical strategy with all these things, and it's a simple thing to say, hard thing to implement, is to upgrade your payroll systems. So there are complex award structures. There's minimum rates of pay, overtime, all that sort of stuff. But this payroll systems in recent times have been really good at kind of displaying some support mechanisms within their piece of software to kind of help that. So I'd always say upgrade your payroll system, but obviously it takes some time to transition. So appreciate that while it's an easy thing to say, hard to implement. And touching on what Sonia's been saying is that legal guidance, awards are complex. Enterprise agreements can be sometimes a bit drafted a bit weirdly that requires a certain level of legal nous to interpret some of those things. But things are not black and white. They seem to always be grey in employment land. And one of the other mechanisms is on a board level, a lot of our clients will include a agenda item for, and I'm going to be a broken record here, but agenda item for occupational health and safety and some of the issues there. I think there's some value in putting underpayments and payroll as another agenda item to ensure that you are complying with your obligations from that perspective. So, and I'm not saying that it should happen every board meeting, but it should be an agenda item that they should consider. And then the other steps are just that you do your audits, like Sonia said, and at times, and this isn't always the case, but if you do find something like that, consider self-reporting to the Ombudsman and taking advantage of some of the mechanisms they have around kind of cooperation agreements and safe harbour schemes that they've got, if it is significant. But I'm not saying every time, but when it is practical to do so.
Absolutely. And, the biggest sort of lesson from that is if you spot an error, fix it first or take steps to mitigate it and follow up with the Ombudsman and so on, because the longer you let it persist, the more fishy it looks, for lack of a better word. But no, that's perfect. Now, our time, unfortunately, today has disappeared. I know we could talk about all these trends for much, much longer, but I do want to thank you all for coming on today and for sharing all your experiences and insights. And naturally, if any of the discussion today sparks concerns for our viewers in relation to their workplaces, there are numerous ways our team at Law Squared can assist in addressing these, and as well as other workplace concerns. Please do feel free to reach out to myself, Jess, or our colleague Andy for a chat, and we're here happy to help. And finally, once again, a big thanks to all of our viewers for joining us today. I've seen a number of your questions trickle through, and I think we've been able to cover off quite a bit of those questions today. But if I have missed any of them, I will definitely follow up with the responses to that. But thank you all for coming, and goodbye for now.
Thank you.
Thanks.